cotton, but it isn't. Even though it's dripping out, how am I supposed to wear it?
I'm so sorry for the inconvenience. We don't have directed policy.
What? Give me a new one.
Welcome to the 8 p.m. news of KKP channel. The case between Trends Fashion House and its buyer. It is based off the according to Section 15 Sale of Goods Act 1957, which is sale by description. Where there is a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description. And if the sale is by sample as well as by description, it is not sufficient that the bulk of the goods corresponded with the sample if the goods do not also correspond with the description. The example case is Wally versus Whip, in which Wally agreed to sell a second-hand machine, which was quite new and used to cut only 50 to 60 acres. But when the machine was delivered to Whip claimed that it did not match with the statement. What happened next? According to the court decision, it was sold by description and Whip has the right to claim.
Next up is Section 60, Implied Condition as to Quality of Fitness. In subsection 1, subject to this Act and any of the other law for the time being in force, there is no implied warranty or condition as to the quality of fitness for any particular purpose of goods supplied under a contract of sales, except as follows. A. Where the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are required. So, as to show particular purpose for which the goods are required, as to show that the buyer relies on the seller's skills or judgment and the goods are of a description which it is in the course of the seller's business to supply, whether he is the manufacturer or producer or not. There is an implied condition that the goods shall be reasonably fit for the such purpose, provided that in the case of a contract for the sale of a specified article under its patent or other trade name, there is no implied condition as to its furnace for any particular purpose. And in bracket B, it states, where goods are bought by description from a seller who deals in goods of that description, whether he is the manufacturer or producer or not, there is an implied condition that the goods shall be of merchantable quality, provided that if the buyer has examined the goods, there shall be no implied condition as regards defects which such examination ought to have revealed.
The case for this particular section 16, subsection 1 in bracket B is that Wilson vs. Rickett Cockrell, in which the plaintiff, a housewife, ordered a coal named Colite from the defendant, a coal merchant. When the coal was put on fire in open grill and it exploded and the plaintiff was injured. Later on, the P sued the D and wanted to claim for damages caused by breach of warranty. And as per the court held, the defendant is liable for its act, since the goods were not fit for the purpose.
As per my advice, I think the Trends Fashion Hub's actions are wrong, as it failed to deliver goods that matches with material description and guaranteed quality. They wrongfully made a description on the shirts being 100% pure cotton and falsely marketed for premium durability and suitability for sensitive skin when it is not. The customers complained on its irritation, rashes and losing durability and color fading, as well as it being 70% polyester and 30% cotton blend. As they failed to meet the standard of merchantable quality, Trend Fashion Hubs is liable for its actions. The no refund store credit only policy is not applicable and the shop must provide a full replacement.
Well, I am going to give my advice towards the buyers. The buyers actually can sue Trend Fashion Hubs for breach of the implied terms and details and also reject the shirts and demand for a refund or also a replacement as per mentioned description earlier. The buyers are entitled for damages for losses like medical costs for their skin irritation and also replacement of a premium 100% cotton shirts in return for the damages. They may also demand for a refund of the amount paid over the defected shirts.
Number 1, they should implement quality checks over their goods before putting up for sales to avoid false advertising claims. Number 2, adopt fair return and refund policies by handling complaints professionally and process refund promptly to enhance customer satisfaction. And lastly, it is to strengthen the supply management by conducting supplier audits and staff training on consumer law to reduce substandard goods risks.
The Trends Fashion Hub is liable for its affected customer. They fail to perform as per sale by description and breach the contract made. The contract is valid and since the shop failed, it is responsible for its action.